Lumpur office, as well as the USA. Her focus on constructions, infrastructure, and energy sectors with extensive credit to great experience ranging from early procurement strategy to contract drafting, advisory during the project's life through the dispute resolution. She has spent more than 30 years in these sectors in the council and advisory roles, including having been second to major complex infrastructure projects, being an in-house counsel at a multinational and found a boutique legal firm in 1999. She is a full-time independent neutral who takes appointments as arbitrator, adjudicator, dispute board member, and mediator. She is a panel arbitrator of various panels, including the AIAC, SIAC, HKIAC, and ACICA. She is a FCIR, FMIR, FAIADR, FCIOB, FNSADJ, and Fellow of the ACIA, member of the DRBF, and holds diploma in international commercial arbitrations. She is a member of the ICC International Court of Arbitrations. So Dr. Shah is a legal academics and alternative dispute resolution practitioner. He graduated with an LLB and LLM from University of Malaysia and holds a PhD from Monash University, Australia. As a fellow of CIR, FIADI, and MIR, he expertly handles complex construction claims under the Malaysian Arbitration Act 2005 and the Construction Industry Payment and Adjudication Act CIPAA 2012, and serving as both an arbitrator and adjudicator. He is also a senior lecturer at the Faculty of Law, University of Technology, MARA, where he educates future legal professionals. So David, our third panel speakers, is an associate dean at RGU with responsibility for the development and delivery for the school's teaching and learning portfolio. But his teaching and research focused on construction law and dispute resolution. Before joining the university, David was a solicitor in private practice at the UK-wide commercial law firm, specializing in construction disputes. He has wide experience in all sorts of dispute resolution processes, including arbitrations, and conducted one of the first arbitrations under the Arbitration Scotland Act 2010. In addition, David also spends time on secondment on an energy supermajor, a Big Four accountancy firm, and on secondment and outsourcing contract review startup in Mumbai, India. Dr. Andre is a lecturer in law at Robert Gordon University in Aberdeen, Scotland. He is a course leader for the Construction Law and Arbitration Adjudication LM program, a module leader for International Commercial Dispute Resolution, Arbitration Law, Online Dispute Resolution, and Advanced Mediation Practice, and teaches many other subjects at undergraduate and postgraduate level. He is an arbitrator and a coach of RGU's mooting team in William C. Witt's International Commercial Arbitration Moot, Vienna and Hong Kong. Before joining RGU, Andre was the head of commercial law team at one of Russia's major energy companies. He is a graduate of Central European University, Budapest, holds an LLM in international business law from University of Manchester, and a PhD from the USLA. And so for the webinar structure today, we will begin with two presentations, first by David and then by Dr. Shah, each sharing their insight on the UK arbitration bill, the rationale for reform, and how this legislative development might impact arbitration practices in Malaysia and elsewhere. After the panel discussion, the presentation, we will transition into a panel discussion where Sui and Andre will offer broader perspective, comparing common law and civil law influences, discussing procedural and case management considerations, and rating the benefits of possible drawbacks of these legislative changes. Following a panel discussion, we will open the floor for questions from the audience. Please feel free to post your questions in the chat box. Finally, we will have a special announcement regarding the accreditations of LLM, MSc Construction Law and Arbitration course by the RGU, highlighting the accreditation with AIADR. So let's start with the presentation by David. David, thank you very much for joining us. Could you please start by addressing the crucial questions? Why reform the English arbitration law now, and where is the process at? And we look forward to your presentation and any initial thoughts you might have on the bill's objective, its journey through the legislative process, and the potential benefits of challenges you foresee.
Thanks, Charles. And thank you, everyone, for coming along, and thank you to the AIADR for hosting this. I'm just going to share my screen. And just in terms of the legislative process, this webinar is extremely topical because the uh, arbitration bill for England and Wales passed through all of its parliamentary stages about a week ago, in fact, less than a week ago. So it's very topical to looking at where we are now that the legislative position has become finalised. So in this brief presentation, I'll give an overview. I'm not going to get into the details, but I'm looking at why now, why do this reform at all? English arbitration has been very successful internationally. Why tamper with something that's working well? I'll look briefly at the substance of it to highlight the key points in the legislation and then look at the next steps. So in terms of why, it's interesting. I went to a web seminar several years ago now on the English provisions and indeed on the Scottish provisions. And somebody pointed out that the 1979 English Act, which was the predecessor of this Act, was passed at the tail end of a tired government looking for good ideas to reform the law that wouldn't necessarily be controversial. The 1996 Arbitration Act in England and Wales was passed in 1996 when there was a tired UK government looking for ways to reform the law that wouldn't be too controversial. The 2010 Arbitration Scotland Act was passed in 2010 when there was a coalition government in Scotland that was looking for ideas that might reform the law that wouldn't be too controversial. And then we saw in I've lost track of time, in 2023, 2024, a tired UK government that was looking for ideas that might reform the law that wouldn't be too controversial. Um, uh, so we had the reform from the English Law Commission looking at some legal provisions. It's interesting, however, that we've now got a new UK government since July last year who took this up. It didn't quite, the 2023 bill did not quite beat parliamentary schedules to get passed um, before the general election last year, but the new UK government took this up, which is interesting that a new government has taken it up. Suggestion of some might say about their political boldness that they've taken up this relatively technical reform, but I think it's good for arbitration that they have done. And also, I think it's a good sign for Asian and arbitration and Asian ADR that they have done so because it shows actually the need for England and Wales to try to compete harder with growing powers in arbitration, especially Singapore, but also Hong Kong and to some extent Dubai. So this is an Asian success story. England and Wales have felt that they need to make sure that the arbitration law is modern and up to date in order that they can compete internationally for arbitration business because it's a significant part of the legal profession in London and therefore a big driver of value to the London economy and therefore to the UK economy. It also, I think, reflects to some extent the changing role of Britain in the world, especially after Brexit, where there is a need for Britain to try and position itself internationally in slightly different ways following its departure from the European Union. So I think in terms of the big picture, that is what drives it. It's also been nearly 30 years since the Arbitration Act was passed, and so it's a useful time just to stop, take a stock check, and see what areas could be reformed. So the English Law Commission did a detailed reform. They followed up with further consultation on particular points and produced this bill. Because of that, because it went through a law commission review, the process through the Houses of Commons has been relatively fast-tracked. It hasn't taken up as much parliamentary time as some things might. However, that does reflect the fact that everything in the bill is non-controversial. If there are controversial points, there'd be more debate, it would take longer, and I think there was seen to be a pressing need to move the bill through the Parliament as quickly as they could, get the reform done rather than getting bogged down in some of the details. When we look at the substance of it in a minute, then that might become clearer. But as I say, the key point is ensuring that English arbitration retains its global standing, especially in an increasingly competitive arbitration marketplace, and looking also at that marketplace more broadly and seeing are there lessons that England and Wales could learn from in their arbitration law and arbitration practice, which is, a good sign of incorporating best practice elsewhere rather than being insular and assuming that you're the best. So two big goals within a political context, I think, is quite interesting. And then what is in the bill, and I'll run through this quite quickly. There are 16, 17 provisions in it, of which there are probably 3 or 4 big topics. The first is that it essentially reverses the rule in ENCA against Chubb by confirming the default rule in jurisdiction, which is that the jurisdiction in which the arbitration is seated will also be the governing law. That is against Enka and Chubb on one reading of it. I know Andre's had thoughts in the past about whether exactly Enka is that clear. But essentially, if there was any doubt, that has now been removed by the reforms to the 1996 Act. You then have sort of two broad thrusts of reform, which are somewhat in tension. But that's interesting, and I think it reflects the academic position of arbitration generally as being something which is both engaged with the parties' agreement, but also subject to the supervision and jurisdiction of national courts. So you have some provisions which strengthen the role of the arbitrator. One of the key problems which parties see in arbitration, and I think this isn't just in England and Wales, but internationally, is the judicialization of the process, it getting bogged down in formality and the need to maintain fairness. So the reform adds some enhanced summary powers for the arbitrators so they can cut through meritless claims more quickly, and also enhances the arbitrator's immunity if they feel the need to resign. So again, safeguarding the arbitrator so that he will get his fee if he has to resign, and therefore allowing him to be or her to be more independent. There is, at the same time, a number of tweaks made to the appeals process to clarify certain issues and to streamline them, allowing the parties to engage the quality assurance mechanisms of the 1996 Act. It's interesting that parties generally, I don't think, want to have appeals when they're starting an arbitration, but when you get to an arbitration, if you've lost, quite often you'll be looking at what you can do next. So there's always a tension in the arbitrating parties' minds and the arbitrators' minds about both having the independence and strength of the process to make it efficient, quick, and satisfactory for all the parties. But against that is balanced the need for there to be quality assurance and checks and balances that if the arbitrator goes wrong, there are ways to test that outside of the arbitration process itself. The bill also codifies the rule in Halliburton against Chubb around disclosure and conflicts of interest, and introduces new powers for arbitrators to deal with emergencies and for emergency arbitrators to be put in place. To some extent, what's interesting is almost the things that were missing from the Act. So the Law Commission looked at rules around diversity, but it was decided not to take those forward in the bill, probably because they would look, there was some concern about international aspect of that, and given the focus of the bill is partly on ensuring international strength of English arbitration, but also because it would be the sort of thing that would cause debate and would be controversial, so it was removed from the bill at this point. They also decided not to codify the confidentiality rules. Arbitration, as you all know, is seen as being a useful form of dispute resolution primarily, or for one of the main reasons for it is that it is confidential. But they decided the rules on that should evolve and continue to evolve through case law, which is interesting, again, as somebody engaging with the law, to see the law is not fixed. It doesn't have to be fixed. There are reasons why particular choices of law are adopted. During the course of the debate through Parliament, there were a few points raised. I think some of the legislation was tidied up slightly. One of the benefits of the parliamentary process is that it engages senior lawyers, arbitration practitioners. They pointed some problems to the drafting, which were corrected. And probably the only issue which bubbled up in the debates, but wasn't taken forward, was around corruption, in particular following the Nigeria against PNID case last year. Lord Hacking in the House of Lords debates was very keen for there to be provisions made for arbitrators to deal more efficiently with corruption. Reading them, they, to some extent, seem a little bit like a hobby horse for Lord Hacking, but then you look at his CV and you find this is a member of the House of Lords who was involved not just in the passage of the 1979 Act, but also in the 1996 Act. So if anyone is in the DNA of the legislation, it's him. So I think his point should be given weight. But I think because of the complexity of the point, because of the need to balance independence of the arbitrators with the state oversight and the need to really get this Act through the courts, those points weren't taken up, albeit all parties, I think, agree that it's important that corruption in arbitration processes is dealt with. And in fact, I think one of the conclusions was that at least in the Nigeria against PNID case, that fraud and corruption was exposed and the system already was able to deal with it. In terms of next steps, so it's been fast-tracked through the UK Parliament. There was only the one amendment to tidy up some of the drafting. We're currently waiting on royal assent, which is the formal approval by the King for the Act to become law. At the point at which it's given royal assent, there will then be a legislative instrument to set a time for which it will come into force. And then the key point then in terms of practical points is what is the transitional point position? What happens if you've got an arbitration that's on the hoof when the Act comes into force. Well, the basic rule in the Act is that that won't be affected. However, if you've had an arbitration agreement which predates the Act, then it will be caught by the amended position rather than the predecessor position. That's all I propose to say, Charles, unless there's anything else.
Yeah, thank you very much, David, for laying the foundation. Now I think we should turn to Dr. Shah to explore the Malaysian context. Dr. Shah, I have a few questions for you. First, in light of the UK arbitration bill, do you think Malaysia's Arbitration Act could benefit from similar amendments, especially considering the recent amendments in Malaysia? Second, how might reforms inspired by the UK bill improve the efficiency or accessibility of arbitration in Malaysia? And the third question is, what are your thoughts on the third-party funding under the Malaysian law, and how might these developments interest with ongoing reforms? Dr. Shah, the floor is yours. Thank you.
All right, thank you, Charles, for giving me the floor. Can you see my slide on the screen before I start?
Yes, very clear, yeah.
Okay, all right. Malaysian Arbitration Act was amended last year, much earlier than England and Wales. So last year, around October, Malaysian Arbitration Act already received the royal assent on 23rd October 2024, and it was published in the Gazette by 1st November 2024. Okay, let me share with you all the key amendments of the Malaysian Arbitration Act, some of which actually reflects the amendment that took place in England and Wales as well, based on English Arbitration Act 1996. All right, there are 4 points, the key takeaway from the amendment that took place in Malaysia last year. The first one is the designation of applicable law for arbitration agreement by way of new Section 9A of the Arbitration Act 2024. Second, the introduction of digital signatures and electronic signatures of an award, amendment of Section 33. Third, automatic recognition of an arbitration award, amendment of Section 38. And the beef out of this amendment is the introductions, to answer your question, Charles, of the third-party funding under new Section 46, paragraph A, subparagraph A to E, and also Section 46, paragraph B to I. So I'm going to cover this point in the next subsequent of slides. So let me start with the first point, designation of applicable law for arbitration agreement. Let me share with you the whole text of the new Section 9A, law applicable to arbitration agreement, which mirror or which reflect the amendment that happened in English Arbitration Act 1996. Okay, 9A, 1, the parties are free to agree on the law to be applicable to the arbitration agreement. Subsection 2, where the parties fail to agree under subsection 1, the law applicable to the arbitration agreement shall be the law of the seat of the arbitration. And subsection 3 says that the agreement by the parties on the law applicable to an agreement of which the arbitration forms a part shall not constitute an express agreement that the law shall also be applicable to the arbitration agreement. So basically, the new Section 9A seek to introduce a default rule or default provision to designate the law of the seat of arbitration as the law applicable to the arbitration agreements in the absence of any express agreement by the parties. So it mirrors Section 6A, law applicable to arbitration agreements of the amended Arbitration Act 1996 of England and Wales. So this is also a response actually to the UK Supreme Court decision in 2022 in the case of Anchor and Sharp, where the default position is crucial to avoid unnecessary legal battles to decipher the applicable law to the arbitration agreement, and it prevents wasted litigation costs and undesirable delays in the resolution of disputes. Let me now move on to the second part of the amendment, which is the digital signatures and electronic signatures of an award. Section 33A, by inserting after Section 2 the following subsection, 2A, for the purposes of Section 2, signatures include digital signatures and electronic signatures. And by inserting after subsection 8 the following subsection, in this section, A, digital signature, has the meaning assigned to it in the Digital Signature Act 1997, and B, electronic signature, has the meaning assigned to it in the Electronic Commerce Act 1997. So basically, the amendment or the introductions of digital signature are a long-awaited and welcome amendment because it will align with the contemporary business practices and the global trend towards borderless transactions. The next amendment that I would like to highlight is the automatic recognition of an arbitration award, amendment of section 38. So the Principal Act is amended by substituting for subsection 31 of the following subsection. 1, an award made in respect of an arbitration where the seat of arbitration is Malaysia, or an award from a foreign state shall be recognized as binding, and upon an application in writing to the High Court shall be enforced subject to section 39. So automatic recognition of an arbitration award where the seat is Malaysia, or an award from a foreign state seek to harmonize the Malaysian legislative framework with UNCITRAL model law, because Malaysia is a model law country that joined the UNCITRAL model law community in 2005. The first time where we had the major overhaul to amend the law took place in 2005. And then second amendment took place 6 years ago in 2018. And after 6 years last year, we had all these amendments. So with this amendment, arbitration award shall be recognized as binding in the first instance court without requiring an application to be made for its recognition. So the idea behind this is to modernize Malaysian legislative framework, arbitration statute, to be up to date, to be in line with, or to be in sync with UNCITRAL model law, because we are UNCITRAL model country. And then the final amendment that raised a lot of eyebrow in Malaysia is the introduction of third-party funding. A new section 46A, subparagraph A to E, and also section 46B to I. So section 46A begins with interpretation of all these terms. For example, A, costs and expenses of the arbitration that address the third-party funding arrangements. B, the meaning of third-party funder. C, the meaning of third-party funding. D, third-party funding agreement, what constitute third-party funding agreement. And E, the interpretation of the meaning of funded party. And then from section 46C to I, it addressed the following issues. 46C, rule against maintenance and championship shall cease to apply because maintenance and championship was maintenance and championship was considered, an obstacle to legalize the party funding, so it ceased to apply. And then D, on the code of practice, where minister may issue code of practice to regulate third-party funding further. Section 46E, non-compliance with code of practice, the consequences. 46F, disclosure of information for purpose of seeking or securing third-party funding. And the main crux of this third-party funding amendment is section 46G on the duty of disclosure on third-party funding agreement. And then the final two sections are 46H, disclosure of termination or end of third-party funding agreement. And section 46I, non-compliance with sections 46F, G, and also H. Okay, let me share with you here the final part of my presentation on the duty to disclose third-party funding agreement as stipulated under section 46G. So it says, where the funded party has made a third-party funding agreement, the funded party shall disclose or communicate to the other party to the arbitration and the arbitral tribunal or the court before the proceedings are brought in respect of the arbitration, as the case may be, and the fact that a third-party funding agreement has been made and the name of third-party funder in the third-party funding agreement. Subsection 2, the disclosure or communication under subsection 1 shall be made A, where the third-party funding agreement is made on or before the commencement of the arbitration or court proceeding in respect of the arbitration upon the commencement of the arbitration or court proceeding, or B, where the third-party funding agreement is made after the commencement of the arbitration or court proceeding in respect of the arbitration within 15 days after third-party funding agreement is made. And finally, 3, for the purposes of subsection 2, if there is no arbitral tribunal appointed at the end of the period specified in paragraph 2B, the disclosure or communication under subsection 1 to the arbitral tribunal shall be made immediately after the arbitral tribunal is appointed. So, the introduction of third-party funding agreements was made to keep Malaysian arbitration law abreast with the development that happening in a more developed jurisdiction such as Hong Kong and Singapore, in contrast to the England ways where third-party funding is self-regulation. Okay, there are some challenges when it comes to the implementation of third-party funding agreement because still new in Malaysia. But more importantly, the whole idea behind third-party funding agreement, other than to modernize Malaysian arbitration law to keep up with the developments of the law in a more developed jurisdiction, third-party funding agreement is crucial to provide access to justice to the parties because we know that the arbitration cost is astronomical. So, although driven by commercial motive, third-party funding plays a crucial role in furthering access to justice. And of course, along the way, there come challenges such as ethical implications when it comes to a conflict of interest. That's why disclosure under Section 46G is important to make sure that the arbitral tribunal independence and impartiality are maintained at all times from start to finish. All right. So there are a few benefits that we got from the amendment that took place in England last year, but unfortunately we are a bit forward. We are one step forward. We only incorporate the provision to designate the law applicable to the arbitration agreement based on UK Supreme Court decision and Chap. Other than that, the amendment that took place in England ways pertaining to emergency arbitrator, continuing duty of disclosure by the arbitrator, and also the summary disposal dispute has already been addressed by the institutional rules under AIC arbitration rules, Asian International Arbitration Center rules, 2021 version as well as 2022 version, but we have yet to incorporate that into our legislative framework of national arbitration law. All right, thank you. That's all from me now. And I'm happy to take the question from the floor during the Q&A. Over back to you, Charles. Yeah.
Thank you so much, Dr. Charles, Dr. Shah, for your sharing. Now, I would like to open our discussion to Sui. Sui, I got one question for you. How do you see the bill's provisions influencing case management and procedural approaches in arbitrations, especially in the Asian context? Considering the mix of common law and civil law influence in Asia, do you anticipate certain unique adaptations or challenges? And also, in what way do you see these reforms impacting time, cost, and overall efficiency of the arbitral proceedings? And from your experience, are such legislative changes in the UK and Malaysia generally welcomed by the user in arbitration?
Thank you, Charles.
This is yours. Thank you. Yeah.
Thank you, Charles, and very privileged to be part of this panel. I must confess that I feel a little bit of an outlier. I am surrounded by academics, people who have done deep dives into the various provisions and make comparisons and what have you. I'm going to be looking at it from quite the opposite angle because I'm really a practitioner of arbitration law. Like my colleagues here, I spent many years as counsel in construction arbitrations, and that's where I cut my teeth on that. And I now only sit as a third party, neutral and independent. So I think that, that's quite important because at the end of the day, arbitration really is something for the people, the parties. And if people are not going to get fed up of arbitration because of the time and cost and don't want to write in arbitration agreements, then frankly speaking, most of us will be out of a job. So we've got to be fit for purpose. We've got to actually keep up with the times. And that means keeping up with the needs of the stakeholders and the users. So I think that, in my view, all these amendments that we're talking about are of particular importance. Before I go and talk about some of the amendments that have been highlighted to us very helpfully, I like to talk about time and cost because time and cost has been like a major topic at most conferences. And if you think about people who fly in from all over the world and take time off their work in order to attend these conferences, it's kind of ironic that we're all talking about time and cost. But it really is a major issue because court systems. I mean, Malaysia is a classic example, okay? I mean, for the longest time, Malaysian courts were talked about as being very inefficient. It was all snail's pace, and you just couldn't get things moving. But we've got to a situation now where the court process has actually been revamped to the extent that people are telling me that, hey, Sui, it's faster to go through the court system and cheaper than arbitration. Now, obviously, arbitration has got its place in the ecosystem, and primarily because of the international enforceability, as opposed to a lot of court judgments which are based on national courts. And where time and cost is concerned, especially in the context of construction arbitrations, which are very, very fact-heavy and very tedious to a lot of people. I mean, there are many arbitrators out there who wouldn't touch a construction arbitration barge pool because they're saying that I just cannot stomach all that detail. And remember, because construction arbitrations has got a lot of detail, there is a heavy reliance on expert witnesses and expert reports, which adds on another layer of cost and another layer of time that's being used. So against that context, against that background, I think that anything that streamlines the arbitral process, anything that makes there to be one less argument, however small or however little you reduce the number of arguments, that is helpful. Now, some of the amendments that we're talking about here, I think are very, very fundamental. For example, you talk about the law of the arbitration agreement as opposed to the law of the contract. A lot of people who are not in the business of arbitration may sort of see it as one. But those of us, and I think that there are many of you here in the audience who are in the business, you do realize just how important that is, in particular when you are actually trying to enforce your award or indeed get interim measures. Now, to have lots of arguments about which law is applicable and to be going almost as if, inverted commas, forum shopping around different countries, that's very, very unhelpful for your client, who is the end user, for whom, at the end of the day, it's all about dollars and cents. So the fact that the UK has got an amendment that addresses that Malaysia has got an amendment that addresses that, I think is very, very helpful because of clarity. This is despite the fact that somewhere in Malaysia, for example, the case law actually, and over the recent years when it's been developed, is actually quite clear. It's actually very in line with what the recent amendments have codified. But the fact of the codification gives you greater certainty because absolutely moving forward, all these lawyers have come up with all these, really clever arguments and how to get around things and how to find new arguments. I mean, they've always taken it as a challenge, how they can confuse everybody else. So when you codify things, obviously you get a certain degree of clarity moving forward, and it takes another amendment. And you've seen David take us through the process of how amendments have to come about. And it's a long, windy road. So, getting amendments through Parliament is not going to be the easiest thing. It's not the fastest thing. So what I'm saying is that therefore you get certainty for a longer period of time. So often we've seen cases that get perhaps either overturned, or in the case of High Court decisions, competing High Court decisions, or in the case of Malaysia, we've got High Court, Court of Appeal, and Supreme Court, unless you get to the Federal Court, which is our apex court, then you might get competing decisions, which gives you lack of clarity. And then somebody like me sitting on the tribunal, I'm being faced with competing decisions on the same issue of courts in my own jurisdiction that are of equal standing. And all that does is actually create more time, more argument in how you're going to deal with this. So, it's almost like gymnastics that we have to deal with. So when you talk about clarity of this nature, I think it's very, very important. The other thing I really wanted to talk about was actually the sanctity and the trust in arbitration. One of the biggest issues about trust, obviously, and I come from an Asian country, okay, so trust and corruption is something that is real. It's real in our everyday lives. I mean, we'll all talk about it. We'll skirt around it. But look, let's face it. Let's be honest with ourselves. It is something that's in our society, and it's there every day. Therefore, when you talk about trust, why should you trust an arbitrator or a tribunal of three? For a lot of people who don't understand the how the tribunal of three works, they often think that the co-arbitrator who is appointed by one party advocates for that party. Some do. Let's face it, some do. Okay. So when you have that kind of situation, then you actually have to really try and build up the trust. And that's hugely important. Trust, as we all know, is very, very difficult to build up, but easily taken away. So where that is concerned, I think that to codify the duty of disclosure of arbitrators, again, gives us certainty, gives us trust in the process. Why do I say that? Because right now, if you look at all the statutes and you look at all the rules of the various institutions, for which there are many now, many, many institutions, but all of them are actually focused on the central issue of disclosure. Meaning to say that if there is anything that is going to possibly create the perception of bias on by any member of the tribunal in favor of one party or the other, then you ought to disclose it. But those duties of disclosure can be difficult to interpret. Most of us will be using the IBA guidelines for conflicts of interest, but guidelines are guidelines. Yeah, they don't have the force of law. So when you codify something and put it into statute, then you have the force of law, and you can literally whack it. You actually deal with the problem head on. So I think that this is something that is going to be very, very well received. We talked also about the division between common law systems and civil law system. I'm common law qualified, but one thing, and I do not profess to know too much about civil law, or have been a practicing counsel in civil law. However, I do see a lot of convergence in arbitration, where hopefully we are getting the best of both worlds as opposed to the worst of both worlds. There's much to be learned from the civil law system, and in arbitration, we try to do that, especially with regards to like document production and a slightly inquisitorial system. I use the word slightly because, I mean, at the end of the day, a fully inquisitorial system, I think, is still balked at by people from the common law jurisdictions. I know this from the list of participants that I can see on Zoom that I think there's quite a lot of people out there who come from common law jurisdictions. So it's something that we actually have to have a little bit of a mindset shift to be able to deal with the civil law thing. So therefore, when you start having codification of practices, codification of requirements and what you can or cannot do, again, that helps with that convergence, that helps with, again, the certainty that we have moving forward. The other thing that somebody was talking about in respect of something slightly different, but the principle applies, which is that although people can agree things separately and independently, when something is actually set in on paper, in words, in writing, and in this case codified, then people actually think a lot more about it, and you feel that the ability to use those tools that are available to you. Tools is something which I think is a very important thing with respect to third-party funding. For a lot of, I mean, those of you, my colleagues here from the UK, third-party funding has been around for a long time. For those of you who are in Singapore or in Hong Kong, you're used to it. For us in Malaysia, it's something that we've been talking about for a decade. Champity and maintenance is something that's always been this sort of phrase that's been thrown around. Malaysia's also had a bad experience with third-party funding with respect to the Sulu Sultanate case, I won't go into the details of that. If you just Google that, you see what I'm talking about. And that also was a third-party funded thing, which I think has made Malaysia a little bit wary about unrestricted third-party funding. But Dr. Shah makes a big point there. Access to justice. Because one of the big things about third-party funding is access to justice. I mean, a lot of times you can actually, circling back again to what I was talking about, time and cost, a party actually can outlast a weaker party by employing tactics that eat up time and cost. Now, third-party funding, I think, is going to help to balance the scales a little bit on that. And I think it's going to be very, very helpful. And, you know, there are all these kind of things about how to regulate it so that it's not like cowboy town out there. It's not just a shoot 'em up. So I think all these things are very, very important. I don't really want to go much more further than this because I think there's a lot to be discussed, and I don't want to be hogging all the time, Charles. So perhaps we can circle back to this later on as well.
Yeah, thank you very much.
more
Thank you so much
topics.
for your insightful sharing, Sui. So
Thank
now I would like to ask Andre a question. Which of the provisions of English arbitration bill would you expect to have the greatest impact, both in terms of the practical terms for English stated arbitrations and on a global scale? Thank you.
Thank you very much, Charles, and thank you very much to my fellow panelists for the insights. It's a sort of a privilege and a curse at the same time to be the last of the speakers. But yeah, you've covered so much ground already. I'll try not to repeat the points you've mentioned, and I'll concentrate on the other stuff. And also thank you for the AIDR. I think it's a very interesting format in which we are meeting today. So there's plenty of events where we talk about developments in one jurisdiction only, but not very many events where we can compare how the parallel courses are going. Unlike Sui, I come from a different end of the spectrum in terms of practice and academia, so I have the luxury of trying to address this point from a more academic perspective. And as an academic, I was very much interested in when the Law Commission for England and Wales opened their first report on arbitration bill. They started from a statistic. They said about 5,000 arbitrations happen every year in the UK, and they are worth at least 2.5 billion to the economy. And I think this argument had been repeated throughout the bill's passage, throughout the consultation. It has been repeated almost every time the bill had been discussed. And this, to me, draws an interesting point. So we are clearly having a case here of what is called in theory a regulatory competition. That is the situation where jurisdictions are competing between themselves for attracting arbitration business, and they perceive the legislative provisions as the suitable means of attracting new arbitrations to the jurisdiction. And the regulatory competition exists in a few areas of law. And one interesting example of which I think is a textbook example is a so-called Delaware effect in corporate law, whereby in these relatively small US state of Delaware has attracted incorporation from the major companies in the UK. And it was pretty hard for the researchers to point out specific reasons. It didn't have lower taxes. It wasn't a tax haven by no means. It had a great judiciary. It still has great judiciary, but was it the sole reason for its popularity? So, I mean, it has been a puzzling effect. So somehow there are jurisdictions that are consistently successful in attracting certain kinds of legal business on the legal, say, corporations, for example. The discussions of Delaware effects and other regulatory competition matters have been, not all researchers are approving of the jurisdictional competition as such, because sometimes it's either seen as a race to the top, for a race for better regulation. Sometimes it's seen as a race to the bottom. And the race to the bottom argument is particularly prominent in spheres such as financial regulation or areas such as crypto. So it may be, you could make a case that attracting business by a jurisdiction can be done by relaxing standards and offering more, straightforward and easy rules for the companies rather than more sophisticated rules. Well, I'm glad to say that, in my view, arbitration is not one of those. I think in arbitration, we clearly have a race to the top. And with arbitration, the competition between the jurisdictions is really to find a most suitable balance for the hearings for the arbitration seated in the specific jurisdiction. And can legislation and principle make or break arbitration business in the country? Well, this is a hard question on which I think it's interesting to find an answer. Well, first of all, arbitration is a very fertile ground for experimentation, because even if you look at the statistics of the major leading arbitration institutes and say even the 5,000 arbitrations figure of the UK per year, right? If you compare this with the workload of the civil courts, so same 2023 England Wales court statistics said that county courts received 1.72 million claims, and if you add all the other courts combined, it goes over 2 million claims altogether, so including tribunals, including family courts, including the high court business, which is substantially smaller. However, these 5,000 arbitrations tend to be the high stake and most important disputes. So arbitration has this luxury of taking a step back and understanding what can be done better in the high stakes, most important cases. So this is a fantastic feature of arbitration. Can the legislation make or break arbitration? Well, it certainly can break arbitration. And one of the textbook examples is I teach in a Scottish university. When we talk about Scottish arbitration for the better part of the 20th century, there was one particular legislative legislative scheme that was pretty much very detrimental to the arbitration. It was the stated case procedure, whereby parties could take essentially a legal question from arbitration, put it forward before the court, and then arbitrators had to wait until the court resolves that question, which essentially killed the entire idea of arbitration being a little quicker than court proceedings. And another case in point is somebody who looks at the arbitration in Russia still with, have a soft spot for arbitration in that country. There were relatively recent reforms in Russia whereby the arbitral institutions had essentially to obtain a license to operate from the country's Ministry of Justice. I mean, for geopolitical reasons, Russia hasn't been a popular seat for international arbitrations, but even leaving that aside, this particular one legislative solution wasn't quite, a boost for arbitration business, to put it mildly, even on a domestic level. Even domestic arbitration had been quite disappointed by that approach. So arbitration legislation can break arbitration. Can you make it? Well, it is a bit harder. So here we are stepping into the territory of small incremental improvements, and there's always space to improve both arbitral rules and the arbitral legislation. And by no means the new arbitration bill, which is about to become Arbitration Act 2024, hopefully, it's not perfect. So even in the Hunter debates, and the last debate that the bill had in the House of Commons, there were highlighted several areas where further development is still possible and desirable. One of them is third-party funding, something on which Malaysia has taken a step forward. So Malaysia is actually a step ahead here than the UK, which is not to say that third-party funding does not happen in the UK, quite the opposite. So more than a decade ago, we have seen a report by Lord Justice Jackson on the costs of the civil procedure, where he has described various mechanisms whereby the costs of civil litigation can be increased by a combination of litigation funding and insurance. And in some cases, it can be increased twofold or threefold in comparison to the initial cost or the initial value of the claim, which sounded, quite spectacular. So maybe this could be the next step. And one other thing that even the Law Commission did not address in its report was the mandatory mediation, which is maybe something where UK is still lagging behind some of the jurisdictions in Asia, Malaysia and Singapore in particular, that pay a lot more attention into incorporating settlement-oriented procedures into arbitration. Among other things that did not make it into the bill, although it was a part of the Law Commission report, was the possible reform about appeals on a point of law. So it's a well-known Section 69 of the 1996 Act, whereby parties can, and this is a default provision, parties can exclude it by an agreement, but if they don't, then the parties can put a question of law. If it is a law of England and Wales, they can put it in front of the courts and thereby essentially appeal an arbitral award. This is an unusual provision. It doesn't think, well, relatively on a global scale, it does not exist in the unswitchable model law. And many countries in the world following completely the unswitchable model law do not follow this. This is one other area where the law in Malaysia and the law in the UK, in England and Scotland both do align. So there is both jurisdictions do have some sort of way the regulation about appeals on the point of law. So I think there's Singapore as well, and New Zealand, and maybe a handful of other jurisdictions, but not that many. And the Law Commission, when they were discussing whether to change the rules about the appeal on the point of law, they were discussing whether this aligns with the prevailing practice in the world. And they saw that, well, actually, it very much depends on the industry. And a very large proportion of arbitrations that do happen in the UK are maritime arbitration, namely the essentially ad hoc arbitrations that are happening under the rules of LMAA, London Maritime Arbitration Association. And in that particular type of proceedings, a particular type of arbitration, the appeal on the point of law remains popular, accepted, and usual way of conducting arbitrations. Whereas in the other cases, such as in the LCIA, London Court of International Arbitration, these types of appeals are excluded by default unless the parties want it specifically. So, and the Law Commission essentially, having looked at this, they said, well, I think we found the right balance. Some like it, some don't, and we still offer enough of the choice to the users, so we don't break that. And I think this appeal on the point of law also leads very nicely to the one of the questions. There was a question in the Q&A already, a question from the floor. Svetlana was asking, in what particular projects is UK winning over HK, Hong Kong, Singapore, and Dubai? And this is an interesting part of the puzzle in itself, I think. So as I said, London's prominence as a seat for arbitration relies to a large extent on maritime arbitration, but also there is a large proportion of other commodities arbitration. So GAFTA, for example, is quite prominent, Grain and Feed Association arbitrations. Whereas in Singapore, for example, about 60% of the cases, there was looking at the statistics, concern maritime disputes and shipping. And if you look into the other institutions, for example, the ICC's portfolio includes a very large proportion of construction disputes. And then if you look into construction disputes as such, generally on a global scale, you can see a very different picture about the popularity of certain seats. So Jus Mundi last year, I think, published interesting statistics where they said that for a construction arbitration, in fact, the biggest number of international arbitration in construction happened in Delhi, followed by Paris, followed by New York, followed by London at the 4th place, and followed by Singapore at the 5th place. So when we see at statistics like that, it becomes pretty hard to say which actually is the #1 forum in the world. It's, you know, the answer is always in law. It very much depends. And in terms of well, but certainly I hope the provisions of the Act are you know, both in Malaysia and in the UK, those improvements are quite welcome. And looking at the second part of Charles's question, what provisions are likely to be useful in practice? I suppose, I mean, there are some provisions in the UK bill, in the English bill, that don't think will have make a lot of difference in practice. So, for example, there is a specific provision now that allows the arbitrators in English-seated arbitrations to dispose of a case summarily. That is, if one of the parties clearly doesn't have a real chance of success. Arguably, this power existed even before, so it was simply an additional confirmation from the parliament that yes, the arbitrator can do that, but arguably they could do that as well. And another thing that the bill has done is they have repealed the provisions on domestic arbitration agreements. So back in 1996, there was a big question for the Law Commission and the DAC on whether or not domestic arbitration and international arbitration ought to be regulated differently. And those provisions on domestic arbitrations had been in the Act, but they have never been actually brought into force. So far, and this is one point where I think English Act and the Malaysian Act do differ a little bit. So those provisions have never been brought into force. Nobody felt the need for them, so the bill simply repealed those provisions to exclude any, you know, any possible confusion. Some of the more practically significant provisions, I think all devil always lies in details. For example, when I was reading the bill and the Law Commission's report, I was kind of touched by how they describe the matter of arbitrators' immunity. Arbitrators are supposed to be immune for what, unless they have committed an act in bad faith or something like that. However, there was a little gap in this regulation, whereby if a party moves to remove, asks the court to remove an arbitrator, even for non-obvious reasons. I mean, you know, it's always a gamble. It's you know, there are some reasons where arbitrator, and most of the cases where arbitrators get removed, they get removed for non-obvious reasons, right? And although the provisions of immunity do exist, the arbitrators in such cases got essentially penalized by legal costs. So they had to bear their own costs in such proceedings if they were brought into court to defend themselves. So the Act closes this lacuna, and that was a very welcome development. And also a small but consequential amendment, I think we now have provisions for emergency arbitrators orders to be enforceable in England, Wales, and for you know, in the foreign seated arbitration as well. So the emergency arbitration itself is a very relatively new concept, but it's nice to see how the law is catching up and providing for an enforcement of such orders, even where the parties have not directly participated in the appointment of an emergency arbitrator. So it doesn't make a big difference. So overall, I'm glad to say that I see a lot of convergence points between Malaysia and English arbitration and Scottish arbitration as well. And I look forward on the arbitration agreement, law of arbitration agreement. It's nice that we have almost identical developments. And I always say at my tutorials that, you know, actually Scotland had this type of provision for a long time. So this is nice to see one aspect where Scotland is being followed by its neighbor, and it's being followed elsewhere in the world. So I'll stop here, and thank you very much.
Thank you so much, Dr. Andre. So before we move on to the Q&A sections, David and Dr. Shah, is there anything you would like to add?
Can I jump in here?
Yeah.
I would like to say that, you know, we talk about amendments in England and Wales. And you think that, well, why is it so important? It doesn't even apply to Scotland. But really, I think that when you look at the larger body of arbitration jurisprudence, the laws of England and Wales and the cases that come up from your courts there play a disproportionately large role in the arbitration world. I mean, there are so many countries in the world, Malaysia included, Singapore included, whereby there's your basis in your body of law, including arbitration, is still grounded on English law, and therefore the cases that are being quoted are still very much rely upon that. So I think that it's very important. Whatever happens there is very important as to what's going on in the rest of the world. I think that with the passage of time, there isn't just an aping of whatever. If we have it there, I'm going to have the same thing. There is divergence, but what I'm saying is that the grounding and the infrastructure is still very important. So, it's kind of funny in a way that there is a lot more amendments and much more movement in many other countries, younger countries, than there is in England and Wales. Because, I mean, you had the 96 Act. This is your first lot of amendments. But it's thoughtful and it's impactful. It's what I like to tell you, that that's the view looking from outside inwards.
Wow, that's very insightful. Thank you so much. So we will now open the floor for the Q&A section. So we have two questions. I think Andre has already answered one question from the audience, saying that in what particular specific projects is UK arbitration winning over Hong Kong, Singapore, and Dubai, oil, gas, building, city infrastructure, and etc. So I believe this question is for David. David, do you have anything you'd like to share?
Thanks. Well, I mean, Andrew picked up the statistics, which are very helpful. Obviously, statistics in arbitration are somewhat difficult because of the confidentiality of the process. So you're relying on the various arbitral institutions to report, and what they report obviously is somewhat skewed, but you do get a sense of what's going on out there. It's also interesting, I think, that English law is often used in these sort of contracts that the questioner mentions. So whether or not the arbitration is heard in England, it's often using English law, even if it's in one of these other venues. And I think the broader point I'd make is that to some extent with arbitration, the perception of popularity is almost as important as the statistics, because arbitral parties, as Sui said, rely on trust and integrity and faith in the system. So if you are seen as being popular, that's an indicator to the market that you're trustworthy. So to some extent, the numbers matter less than that perception in the marketplace about, is this the right place to try my dispute? Is one of the reasons why, over the last 15 years or so, been watching Scotland try and enter into the marketplace. And this isn't a plug for Scotland, but what is it that Scotland's doing differently to gain traction in the arbitral marketplace? And part of it is just generally building a reputation. You have to build a reputation. Andrew many years ago told me that building an arbitration jurisdiction is like having a nice lawn. You basically, all you need is good quality earth, good quality seed. You just have to put them together and then water it for 100 years. And that's a bit like that with arbitration. And sorry to steal Andrew's thunder there, but that's what happens with these numbers. They're indicators to the market of credibility as much as anything, but it's the credibility that really counts when you're competing.
Can I jump in there, David, on something anecdotal? Just building on what Andrea was saying about the popular arbitration seats and popular institutions. LCIA has just got their new registrar who came from Singapore, right? So from one popular seat to what is apparently an even more popular seat. So London is still way up there, definitely.
Thank you so much. So I think we got another question, which is for Dr. Shah, which is under Malaysian Arbitration Act, upon arbitration can only be enforced upon submission to High Court.
Thanks, Jas, for the questions. Yes, enforcement of the arbitral award can only be made through the High Court under Section 38 of the Malaysian Arbitration Act. And with the recent amendments that took place last year on Section 38, enforcement process is going to be a lot more efficient because of the automatic recognition of the award. Okay, where the seat of arbitration is Malaysia or an award from a foreign state, where the award shall be recognized as binding automatically. So in that sense, you don't have to make a separate application for the recognition of the award because it's automatically recognized before the enforcement take place. However, bear in mind that Section 38 has to be read together with Section 39 on the grounds for refusal of the recognition enforcement, particularly on the public policy ground and also on the due process grounds such as natural justice and also exercise of arbitrated jurisdiction. So that is governed under Section 39.
Yeah, thank you so much. Sri, I think you are going to add something.
I just want to add to the fact that, that's exactly one of the things that's really important, because what's the point of a nice piece of paper of a 500-page arbitration award if you can't convert it into cash? So it's all about that. And why is arbitration so successful? A lot of it is because you can then get the award recognized in so many different places because of the New York Convention. And I think that we cannot lose sight of this. Sometimes I feel that in all these 30 plus years of practicing in arbitration, that things have become much more complicated. And we often have to just go back to basics. What is it that we're trying to do? What is it we're trying to achieve? And how can we achieve it? So, to a lot of the younger practitioners who are listening in, who are getting caught up in a lot of the arguments, take a step back, think back to basics. And you might actually do your client a favor, I think.
Thank you so much, Sri. And so I think we don't have any further questions. So on behalf of the RGU and our ADL, I would like to extend my sincere thank you to our panel speakers for sharing their valuable insights today. The UK Arbitration Bill represents a critical juncture in arbitration law, and understanding its potential impact both domestically and internationally help us to grasp the future of alternative dispute resolution. So the comparative insight into Malaysian legislation that we have discussed today have been particularly illuminating, offering a unique perspective of how global reforms can shape the local practices. So, so I think now before we close, I'm delighted to make a special announcement about the RGLM in construction law and arbitration law has been accredited by the AIADL. So I would like to move the floor to Dr. Andre for further clarification. Thank you.
Thank you very much, Charles. It gives me great pleasure. I don't think it's an announcement as such because everybody who wanted to know about it knows already, but I wanted to touch on some of the more detailed provisions. Well, first of all, I would like to say I'm really delighted to have this cooperation going on, this collaboration. And as I have alluded already, there is a lot of similarities between the English and Scottish acts and the Malaysian Act, which kind of allows us to see the future in this collaboration. And in this vein, RGU, Robert Gordon University in Scotland, we are very much Scottish university, I'd like to highlight that, rather than English university. We have a very popular course on construction law and arbitration, so dual either LLM and MSc, and it is the course that draws lots of people from the industry who see themselves further practicing as arbitrators or adjudicators. And also, as I alluded to, or even if I didn't, I wanted to say that Asia generally, in terms of the arbitral seats and in terms of jurisdictions, I think Asia is clearly on the rise. Singapore being case in point, but of course Kuala Lumpur and Malaysia as such is along the way, so it's becoming more and more important. So and in this vein, we are delighted to add the accreditation from AIADR of this course to our small portfolio of accreditations. And looking at the details, so what the details look like. I would encourage all our students to consider AI-ADR membership as they proceed through the course. And the specific arrangements. I have a paper in front of me just so I don't misguide you here. So the current accreditation arrangement is as follows. So the students who on LLM, on Clark construction law and arbitration, who successfully complete the full degree, including the award writing or decision writing short course, will be eligible to apply for a fellow membership with AI-ADR. Students who complete the first year, that is a law of obligations and evidence, and either arbitration law practice and procedure or construction adjudication law practice and procedure. So that's a membership exemption. And also an associate level exemption is available to those who complete one of the following modules, either theory and principles of conflict and dispute resolution, or mediation and practice, or the award writing or adjudication decision writing short course. So regarding the latter, it is an advanced course. Award writing or decision writing is a kind of advanced matter. So we have certain requirements accepting internal and external people on it. So it's probably not a course for a novice. It should be somebody with a fair grounding in arbitration and adjudication law already. So that said, the module alone, arbitral award writing or decision writing, attracts only an associate membership. However, we recommend those with the background in arbitration and adjudication to consider the other credentials. So in combination with your other credentials, for example, if you've done our LLM in the previous years, or if you've done a similar course with another university, you could apply for a member or a fellow level exemption. That will be decided by AI-ADR according to their procedures on a case-by-case basis. Yeah, that's the small details. This is a small font. Thank you.
Andre, can I add a fun fact on the theme of collaboration with Malaysia? That there is actually a hotel in Aberdeen that's owned by Malaysians.
Oh,
So there we go.
Do you know the name?
That's a even greater collaboration. I won't name it just in case I'm accused of being biased.
Sure. Of course. I'll find out.
Thank you so much, Dr. Andre, for the informative session. And thank you so much, Charles, and a big thank you to our panelists for such an insightful discussion. I'm sure our audience has gained valuable perspective on how amendments are influencing the arbitration landscape. With that, to all our attendees, thank you for being a part of today's webinar. We hope you found this discussion to be insightful, beneficial. If you wish to explore further opportunities with AI-ADR, including our training programs, professional accreditation, and membership benefits, please visit AI-ADR. I also noticed that there is a question in the Q&A. I think this would be for Dr. Andre. They're asking, when will the next award writing course be run? So Dr. Andre, maybe you could address that. Thank you.
Thank you. So we have two courses running this year. Adjudication decision writing is scheduled to start earlier this year. We plan to start it on the 30th of April. So therefore, the registration will open sometime in early April, most likely. And the arbitral award writing is scheduled to start in the early days of first days of June, so second, third June. Therefore, the registration is likely to be available in May. The procedure is usually, if you would like to enroll on that on the short course, drop me an email and I'll compile a small database of people wanting to do this. Once we open the registration, I'll send you a link and a reminder where you can register for the course. So, and that is available to current RGU students. So especially if you've gone through the first year modules, but it's also available for external candidates only if you can show that you have some background in arbitration or adjudication respectively. Thank you.
All right, thank you so much, Dr. Andre, for that. And with that, we would like to end today's session. However, before we end, we would just like to take a photograph of our panelists and the moderator. So I'm just going to give a short countdown. So on the count of 1, we will take the picture. 3, 2, 1. All right. Thank you so much, everyone. Thank you so much, dear panelists, moderator, and attendees for attending this webinar. For any other further questions, feel free to reach out to either the RGU or the Secretariat of AIDR, and we'll be happy to assist. Thank you. Have a good day, everyone.
Thanks,
Thank you so
everyone.
much.
Thanks,
All right, you're
everyone.
welcome.
Thank you very much.
Thank
Thank
you.
you.